Hi, everybody. Toni Marcolini. Welcome to the podcast. It may interest you to know. Today, I'm returning to my roots. I'm doing a podcast on the law. Now, as a rule, I focus on creativity on the podcast. So we have lots of authors and screenwriters and filmmakers, and people creating all sorts of things, music. I'd like to talk about creating a different outcome in litigation today. Lots of jobs can be creative, even if they're not making a sculpture or drawing a painting. There's different ways to be creative in the world, and I certainly think the law can bring some of that to it as well. All right, sure, there's trial work where you go before a judge or jury and you get to an outcome, but there's also creating different outcomes. And I think that's what alternative dispute resolution is all about, getting to some place where you can craft something creative, thinking outside the box, something that wouldn't happen in a court. So, in that vein, I have two panelists with me today, a frequent co-host, retired Judge Honorable Bradley Ferencz. And I also have with me Shaun Blick, an esteemed colleague and attorney here in New Jersey. And so welcome, Judge Ferencz and Shaun.
Be here again, Toni Ann.
Judge, I thought you could maybe open the door for us, because there's all different alternative dispute resolution types of processes that can be presented in a case. And I think mediation is probably the one people are becoming most familiar with, although for a long time it was arbitration. Right, so maybe you can explain the difference between arbitration and mediation.
Well, I think before you start, people need to understand exactly what litigation means and what it's involved and why it is probably, well, the best alternative. Also, it's in very, very many cases, the worst alternative to resolving a dispute. Um, I was involved on a personal level when I first started doing criminal work, litigation, trial work only for 20 plus years, and then moved from there to the bench. And I spent about 20 years on the bench. And I find that while it was a great job and it was a really interesting time, I found that towards the end of it, I was kind of getting tired, and it might sound silly, of telling people what to do. Because when you're on the bench, that's exactly what it is you're doing. You are basically making decisions for people and telling them what they should and shouldn't do, what they can and cannot do. And often, especially in the family part, when they can and cannot see their kids. Nobody, in a real sense, should be telling people when they can and cannot see their kids. Nobody really, in a real sense, should be interfering in the family structure. That really ought to be decided within the family, even when families are dysfunctional. It really ought to be there ought to be a mechanism to have people get together and try and resolve it, rather than giving it to some third party who's not going to know anything really about the history, who's never going to sit down and say to any of the parties, how you doing? What do you think? How do you feel? What's important to you? Because we as judges, we're told, we're instructed, we're taught to decide a case fairly, which is good, to decide a case without bias or prejudice, which of course is also good, but without sympathy. We are literally told, take sympathy out of your judgment. Decide cases objectively. Find what the facts are. Put another way, judges will listen to testimony. They'll listen to examination, and they'll make a decision as to what the facts are. The reality is, we don't know the facts. The litigants know the facts. We don't know what's important. The litigants know what is important. One of my favorite stories, and you'll pardon me if I digress, because it really shows the necessity of negotiations, which is really what mediation is, assisted negotiation. I was sitting in the family part in a hotly contested divorce, and one of the litigants' lawyers, because judges don't talk to the litigants, they only talk to the lawyers, hands up 3-page, single-spaced, sheet and list of things that need to be divided, and says, Judge, we can't do this. Will you do it? Being a good judge, I did what well, not all judges do, but many do. I said, sure. And I flipped a coin and it came up heads. So I said, okay, plaintiff, you pick first. And the plaintiff picked something the defendant wanted and started screaming. I said, whoa, wait a minute, guys. Look at your lists. And this is, although I have to tell you, I'm somewhat of an atheist, if not at least an agnostic, I'll say, as God is my witness, on that list was half cans of paint. Now, I will ask each of you, you're both well educated. You've both been to paint stores. Do you have any idea what those cans of paint are worth? Do I know whether they belong to your great, 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 great grandfather in the Civil War and they really have a significance? I don't know that. Do I know that they're a color that no longer exists that you really want in case you want it matched because you really love that? I have no idea how to value a half can of paint. So I said to them, you go out, you decide it, you know how to put value on things. That is what mediation is about. Taking a case
Judge,
that's
I have to interrupt you. You're traumatizing me, right? Because the very, very first time I appeared before you, right? Like literally the first time I'm there. I mean, I was young, a new lawyer. It may have even been my first bigger trial. Um, and I'd had smaller hearings, I think, before that, certainly. But I think my first big trial was before you. And we had the exact same situation where they were fighting over who had what, and somebody had taken stuff from the house, and then we have the list who has these items, the back and
Mhm.
forth. And you basically said, I don't know. So why don't you two, go hop in the car and go look in their place? And you like literally sounds like, no, I don't want to do that. I'm like, I really don't want to do that. And the lawyer, who I won't say on the air's name, but I will tell you after we stop recording, jumped on it. And he's like, oh, that's a great idea. I love that. And I was like, no.
No.
And you sent us right out. Like, you go do it. You go take your clients and drive to the house and see if he's really got this stuff. And I was like, oh,
Right.
okay.
And what happened?
Uh, well, we just moved the fight to a new location, actually.
Now, if you had had a third party there helping you negotiate it, you would have had a mediation, and I almost guarantee you it would have been much smoother. You would have been resolved and would have taken less than a day, and you would have had it done and moved on. I literally was getting so frustrated at being a judge because just deciding things all the time. And we had a thing, an organization called the Administrative Office of the Courts that demanded statistics. And I didn't sign up on the bench to be giving people statistics of how many cases I moved in any given day or week or month, or how many motions I heard, or how far behind I was in resolving a case. I was there, as simple as it sounds, to hear cases and try to do the best I can to resolve them fairly. And I had a cup of coffee at a local Starbucks with a friend of mine named Shaun Watts, who was teaching a course at Columbia Law School. And he said, why don't you come on in and take this course? And I said, well, it's given during the week. And he looked at me and I said, you know what? I'm going. And without telling my boss, the assignment judge, who to this day does not know I didn't show up for 4 days in a row, I went in and I took this course at Columbia Law School in mediation. And from the moment the teacher started talking, I was just enthralled because here was really for the first time somebody saying, hey, you know what? Maybe litigation and putting a decision in the hands of a third party isn't the best way of resolving a matter. Maybe the best way to resolve a matter is sit down with somebody who's somewhat trained or somewhat empathetic, who can actually listen to you, help you achieve the goals you're looking for, and settle the matter reasonably and fairly, with your input of the parties, who, as a result of being there, can decide what's most important to them. Um, I don't want to monopolize this, so I'm gonna close this and open this thing up for discussion. But I am reminded, yesterday we had a Super Bowl. I'm not much on, it's not the most important thing in the world, but I am entertained by it. They had two teams who went through an entire season to get there. Pretty darn good teams. Would you say either of those teams are bad? Either of those teams had a losing season? No, there were two really, really good teams. Yet at the very end, after an overtime touchdown, I mean, they had to go overtime. It was the last seconds of the game. I think there was like 3 or 4 seconds left on the 15-minute overtime clock. Kansas City scored. What did you see afterwards? Only Kansas City. There was no interview that I saw of the 49ers, who had an awesome, awesome season. The 49ers had the best season in the NFL. The 49ers, who had a quarterback who was taken last and paid a scant 800 plus $1,000, lowest paid quarterback in the NFL. You know, nothing. You got to say they had a zero. You got to say, you can't get around it. Kansas City had a +1. Well, I'm not a mathematician, but you take a +1 and a -1, you add it together, you get a 0. Overall, that's a zero-sum game. Litigation, in a very real sense, is like that. You want to try a case, you might win it, you might lose it. You never know what a jury's going to do. Well, you never know what a fact finder is going to do. But if you win, they lose. If they win, you lose. Mediation, negotiation, sitting down and trying to work stuff out, you may not get a 1, but maybe you get a .8. They might not get, a 1, but maybe they'll get a .8 because, maybe you can compromise on stuff. Well, .8 and .8 is I think it's a 1.6. My math is not real good, but it's a lot larger than a 1. So I happen to really think that mediation is something that not only works, but in fact, it is actually not only works, it is actually mandated by the courts. It works well if people are willing to resolve their stuff. And most people are. I could go on, but I don't want to go on until I give somebody else the opportunity to chime in because I'm actually teaching the mediation practicum at Rutgers Law School, and I got to tell you, it's fascinating to watch the kids get involved in discussions back and forth, trying to resolve fairly and objectively two sides of an issue based upon a fact pattern that they're given an hour ahead of time. It really is a great process, and it works well for people who want to make it work.
I'm going to take a minute to profess my love for this guy on record here because he just is unreserved, no holds barred, and I think that's what makes him an incredible mediator and in his prior life jurist. I get the benefit of dealing with that on a daily basis. So from a personal level and seeing what he does in the mediation context is just amazing. Um, you didn't ask, but I'm going to jump in here and tell you that of course, there's a different perspective from the litigator side, the person handling the case. All too often, I see it. I have clients that are very desirous of getting to a resolution, but they just have stumbling blocks, either because of personalities, or there are what you would perceive to be these petty things that stand in the way, like paint cans. Um, and as the lawyer that's holding the hand of the respective litigants in these situations, I'm just dying for a mediator to step in and inject his or herself into the middle of it and say, come on, everybody, what are we doing here? Let's get a dose of reality and let's pull it all together. This is a dispute that can and should be resolved. And oftentimes, you don't really see that from mediators. That's what you should see from mediators, but you don't.
Well, Shaun, you raised an interesting issue because there are two different schools of mediation. One is a much more collaborative, let's just talk, kind of mediation. And the mediator really relies on the litigants to come to their own resolution. And that's really very useful in neighborhood disputes and social disputes and allegations against police departments and public officials, where it enables people to vent. You can't vent in a courtroom unless your name is Donald Trump and a judge refuses to, arrest you. I've been asked, by the way, I know this is an aside. I know you can edit it out if you choose to, but
I
I've been,
have to edit that out, Judge.
what would you do if that appeared before you? And I said, I don't know. Anyway, I know you can edit out, but I had to say it just because I was thinking it. Anyway, so the collaborative type of mediator literally does not involve themselves in making recommendations. And there's a whole school of thoughts that believes because resolutions should be litigant driven, the mediator shouldn't be making recommendations. The mediator should not involve themselves or make suggestions, but rather than saying, you really ought to think about taking that $25,000. You really ought to think about taking that table because it's worth a lot more than the chairs. Rather than doing that, you've got to let the litigant decide it. You've got to encourage them. Do you really think the chair is worth as much as a table? Let them come to the conclusion. As you know, Shaun, I'm much more of the other side of the equation. I am a directive mediator. I start my mornings very laid back, making sure that the parties understand it's their mediation. It's their decision what to do. You should rely on the lawyers. You should make sure you talk to your lawyer. I don't represent either party. I'm in the middle. I've got no, as they would say, um, dog in this fight. This is between you guys, not with me. But by the end of it, when somebody is having a rough time getting over, an issue, and there are lots of things, and you raised it, Shaun, that stand in the way of resolution. There are sometimes profound, and I say this without hesitation, religious issues that come up where somebody does not believe that a divorce should be given, period, and won't be given, or that a divorce, should be given, but there should be no alimony or no child support or no consideration for the other party. And one of the things that I have the ability sometimes to do is to discuss with those litigants, hey, that's just not what the law is in New Jersey. And you're going to have to deal with those issues because if you don't and you go to court, these are the likely results. This is what a court could very likely or possibly do. Will you raise an issue, Shaun, when you talk about you're waiting for the mediator to come in and shake the guy up and say to the litigant, what are you thinking? What we can do often is help the lawyers inform the client, inform the litigant of the reality of the position that they're in. Most lawyers, not all, but most lawyers understand that they want to keep their clients happy. It is not a real good vehicle to make somebody happy to give them bad news. But we as lawyers understand that sometimes the results can be very bad if you go to trial. We as lawyers understand that sometimes the offer on the table is a heck of a lot better than the unrealistic possibility that something better will come along down the line. Lawyers really have a difficult time sometimes, and some more than others, looking at a client and saying, your case is awful, because the client's response is, and why did you let me bring it? Why are you letting me spend this money? Lawyers want to make clients happy. Mediators are able to step in between, if you will, the lawyer and the litigant and help the litigant understand and take the weight, if you will, for the unfortunate happenstance that the client finds themselves in and not get the lawyer blamed for being the bearer of bad news. It happens time and time again. I once said to somebody in a mediation, and it was repeated to me, I didn't even know I was saying it, what is it you want? I just got you everything you asked for. What more do you want? I just thought I was doing a job saying I got what you wanted. Now what? But the lawyer was just amazed that somebody would actually, I don't want to use the word confront, but actually say to the litigant, what do you want? As a judge, and I think you guys as practicing lawyers would agree with this, I've never asked a litigant, what do you want? I've never said, counsel, you mind if I talk to your client? What will make you happy? What are your goals? What will satisfy? I've never. I speak to the lawyers. You know what it must be like to sit in a room and have absolutely no control over your life? Shaun, Toni Ann, you guys are both lawyers. You both represented people. Can you imagine what those folks feel like when the only link to the result that they might get is you, and your only link is that court, and you don't know what that judge is going to do, period. Totally out of your control. Anybody here like it when they're totally out of control? I know I don't. Anybody like it when they can't make the decision imposed upon them? I didn't like it when my mom told me what to do. And then I was like 12 and I listened to it, but I didn't like it. I haven't gotten any better as I've gotten older. Mediation removes that impediment and replaces the judge with the litigant. They decide. I could keep on going. I mean, I start my classes at Rutgers with a full weekend from 10 to 4, 2 days in a row, and I lecture the entire time. So you're going to have to cut me off, guys, because I really am excited about the mediation, what it means, how it works, and why it works.
Well, I mean, first I want to clean up one little thing, with regard to mediation, in that it's not arbitration, right? I think people hear a lot about arbitration, especially since contracts tend to have arbitration clauses. Even now with their employers, a lot of people are signing things that have arbitration clauses in,
Mandatory arbitration clauses, sure.
right? And so I want to clear up the differences between those two things. I mean, an arbitration is typically totally removing a case from the court system where you go before, whether it's a retired judge or somebody, with proper training who's going to act as the judge, but in a less formal setting, right? You're going to go probably to that judge's, retired judge's office. You're going to put on your trial like you would have in a courtroom, but again, in a conference room. So there's a relaxed setting somewhat. And then when you're done, that judge is going to make all the decisions just like he would have if you were in a courtroom. You get to control the certainly the press coverage. So often you see it, that's one of the reasons I think employers put it in their contracts, because it's not like an open courtroom. It's a more private setting. It's a less costly setting because litigation can go on and on and on for years and cost you six figures by the time you're done. And just to get to an unhappy outcome, a lot of people are opting, and I think employers put it in arbitration because it's smooth, it's direct. Within a few months, you'll get it. It'll be over with. And appeals won't go on and on. There's very limited grounds you can appeal it. But then there's this other vehicle that's gained in popularity, I'd say over the last decade, known as mediation. That is not anyone making a decision for you, but a process whereby you agree to go to somebody who's going to help you settle your problems. Now, this is where I think people probably want the most information. A lot of times you're going into that saying, he's never going to settle. She's never going to settle. We couldn't settle on our own. We had a four-way. We've had proposals going back and forth. I mean, this is never going to work. It's a waste of time. It's a waste of my money. And that's where they begin walking into mediation, right? They're convinced the other person's never going to come around. And I will say I've been in many cases where they are so entrenched in positions that are favorable to them and them alone, that trying to make a litigant understand, why would this person agree to that? Like, there's nothing in that for them. Compromise. Compromise is hard for a lot of people. Right? Compromise, they know what they want. They believe they're right. And with believing you are right, I guess, in anything comes a stubbornness that doesn't allow you to go, okay, so I'm right, but they're not giving prizes for that this week, right? I still have to try to get this done and come out with my family able to move forward. And I think that's where mediation is invaluable, because it helps you see I, I need to open my mind to other solutions here, or it's going to be another 2 years and another $100,000. And that's where I think the value of mediation truly is. Now, there's two different forms of it. I agree with what the judge said. There's collaborative, where the judge really is more like a psychologist. Like, how do you feel about that? Like, where they're just trying to get everybody to have their input and open up that kind of a dialogue and a forum.
And Toni, they're not exclusive. Every mediation should start with a collaborative mediator.
I agree with that.
Every mediation should start with whoever is doing the mediation listening.
And why is that? That's because you have to develop a trust.
Yep.
You need the parties to open up to you. You need the attorneys to open up to you. I agree with that 100%.
And then by having people actually listen to you, they feel heard, they feel comfortable, and they're more likely to listen to alternatives to the entire pie. They're very simple question that people have to think about. Do you want to be fair? There are some people, but a very, very small percentage, who say, no, I don't want to be fair. 90% of the folks out there, 95% of the folks out there want to be fair. Now, they might think fair is a much larger slice of the pie, but they want to be fair. And we as mediators need to help them define what fair is. We as mediators have to work with them to make sure they understand that, they have to give to get. They have if they want something, okay, well, what would be fair? What can you give up? What can we do? You want Custody, okay. How can we arrange that? And mediators talk in the positive. How can we get that done for you? How can we, what can we offer to secure that which you feel is most important to you? Um, it's a process that can take a while. I, on a personal basis, will not set a mediation down for any less than, I'll call it a day, but they may not take a full day, but I will only schedule one mediation in a day because I want people to stay and listen and talk. And people need to feel heard. They need to feel that they're vented. They need to feel that they've had the opportunity to really, in a sense, purge. Because there's a lot of anger involved in litigation. There's a lot of dislike. Nobody goes and sues somebody, whether it be contractual, because or matrimonial or family because they like them. You know, people do it to get something. People do it out of anger and sense of entitlement, out of disillusion for a whole lot of, unfortunately, negative reasons. Good mediators are trained to accept it, to understand it, not to be judgmental, and just try to really calm things down. Does it always work? No. But you find that if you really listen to folks, they usually react pretty well if they feel they're being listened to. They
This
usually
is
react by calming down and listening themselves. The story that, if you're standing on a bridge and you've got water running under that bridge, and it's that water represents time. I can't get you that water that's already passed. I can't go get you that bucket of what happened last week, last month, last year. But what I can do is I see a sailboat coming down. I can open that bridge for the sailboat. I can make sure that whatever water is coming down can be dealt with fairly, that you can get your fair share, to run your, windmill sort of, or your turn mill, as the water comes by. I can't change the past. And very often people that come in are living in the past. You got to work slowly, get people to understand. Sometimes it can be done in a day. Sometimes I've had 2, 3, 4 days of mediation before it finally gets resolved. And the thing about arbitration that you talked about is very often what will happen is if we have 1 or 2 issues that don't get resolved, the lawyers very often, if you develop a good relationship with everybody, will say, Judge, will you call this last issue? Will you decide, whether we can have 2 weeks consecutive in the summer or 1 week in the summer, by way of parenting time? Will you decide whether or not it's got to be the $10,000 has to be paid, by next week on Tuesday, or can they have 2 months to pay it? And that's the kind of thing where you have a kind of an arbitrated portion, but a mediated result. Courts can't do that. Courts are very linear. Courts are not, you talked when we started this thing about creativity. And I mean, no disrespect to my brothers and sisters on the bench, but creativity is not a course they teach at Judicial College. It's very linear. Here's your case. Here's the facts. What's the decision? It's normally, for lack of a better way of putting it, about dollars and cents. But it's really very, again, I don't want to say uncreative because there's a lot of thought process that goes into it, but it's not supposed to be, a deviant resolution. Whereas with mediation and even some arbitration, there's a lot more flexibility. You talked about arbitration, and I think you hit the nail on the head, Toni Ann, because arbitration is contractual in nature. And you can contract for whatever it is you want to contract for. So, for example, one of the things I like to do is I like to have arbitration with mediation, understanding that arbitration comes in both binding and non-binding. You can have an arbitrator make a finding that's not binding on people. I, on a personal basis, won't do it. That's like offering an opinion. Everybody's got one. If you want my opinion, it's got to mean something. Otherwise, you guys can decide we'll just mediate it. But when you can get somebody to agree to a binding arbitration permitting mediation, you have what is as close as is possible to what goes on in a courtroom, where you will call the lawyers in before you start the trial and look at them and say, counsel, can we resolve this? Which is exactly what the courts do. You guys, I know how many know what percentage of cases actually get litigated? Shaun, do you know?
to a trial?
Yeah, to trials, to verdict.
It's got to
Not
be
cases that even start trial and then get resolved before that verdict comes in, but we'll call the civil division. Generally
extraordinarily low.
3-4%.
I'm guessing maybe even less.
What happens to the rest of them? They get mediated, they get resolved, they get binding arbitration where you can pick the person that's going to decide the case. Now, picture you go into a courtroom. You don't know the judge. You got the luck of the draw. Could be good, could be bad, could be, somebody that, was in the same firm as you 10 years ago or 5 years ago and used to be very close to you, and maybe you're going to get a break. On the other hand, maybe he was an adversary or she was an adversary, and you're really not comfortable. You can't do anything about it. It's on a rotating basis. But with the binding arbitration, you pick the person and you say to your other lawyer, hey, what do you think of getting Shaun to arbitrate this? He's got a particularly, Shaun, what do you got in the office? You got some people that do construction work?
Yep.
They're experts in construction?
I would say so.
I know that you use nails in construction. That's about the extent of my construction knowledge. Two people sit down, they work with both those guys that work in your office and say, you know what? We don't want this going to Judge Ferencz because he doesn't know anything about the subject matter. Let's take this to some guys that know something, and he can call up and say, let's get Jim Ross to it. Let's get Joe McNulty, the guys that are working in Shaun's office, to sit down and do this binding arbitration. They'll make a finding, but they've worked with this guy before. They know him, and they know he knows the subject area. They can select the arbitrator to do it. You can't select the judge to do it.
Well, and I also think, what's important about the mediation process, because litigants, they're not always excited about it, believe it or not. Right? They're not always excited about starting it. They don't understand it. And often, Shaun, you can jump in and tell me if I'm wrong, if you've experienced something different. But there's a lot of pushback when you initially say we have to go to mediation. I
I,
mean,
I
clients that they
think
usually tell you, no, let the judge decide.
no, I think there's a lot of bravado and brazenness attached to the litigation process. Everybody wants to flex their muscle and they want to show the other side that they're right and their lawyer is better than their lawyer, and you know how this goes. But what I have found as both a private mediator and a court-ordered mediator on the mediation roster is that by the time the litigants come to my mediation table, they want to tell their story. And they want to tell their story in a way that is unimpeded actually by their lawyer. Because I will ask them and I will say, if their lawyer has no objection, I say, this is your day. Okay, this is a possibility that we can get this case resolved today. In fact, I'm all yours. I'm going to shut that door and I'm all yours for the duration of the day or however many days it takes. And I'm committed. Are you? And then we go through it, and then the people will tell me. They'll tell me exactly what it is that they have going on, what's the dispute about, what's important to them. Um, and oftentimes it might be something different than what's included in the confidential mediation statement, which is always interesting. And so, yes, there's a certain level of collaboration. We talked about the different kinds, the court systems, court order mediation program, that of New Jersey, that is, requires the collaborative method. But my experience has been, I can't quantify this to a percentage, but I will tell you in most of the cases that I handle, at some point at the end of my mediation session, I will either get from the lawyer or from the litigant, Shaun, what do you think? What do you think of this? And I say, okay, do you want me to deviate? I'll do it. I'll give you my opinions, but understand that that's not the court's directed way to handle these things. In private mediation, of course, I'll give them my opinion. Um, but they're looking for a third party opinion sometimes, and this is their first opportunity to take the case before there's a trial, and they're going to tell their story to somebody that hasn't heard it before, and they're feeling out the room a little bit. They're feeling out their chances of success on the merits from a third party, and I think it's critical. And I think you just don't get that opportunity in the litigation context because A, it's very rare that you get in front of the judge as a litigant before there's a trial. Um, and B, depositions don't do that. I mean, you're taking your very one-sided story without the collaborative process, without a third party. You're just setting the stage for the facts. So that doesn't really match up to it. So I think a lot of attorneys maybe should do a better job at pushing the parties into alternative dispute resolution to at least get that third party perspective for the case, for the merits of the case, for the substance of the case.
Well, I'll tell you what else they don't do in a courtroom. They don't meet with you alone. Right. Whereas a mediator will separate you and give you an opportunity to you and your lawyer to speak, and then shuffle back into the other room and talk to the other party. Whether we're talking a lot about family law, but it can be anything that's being mediated, any dispute that's before the court. But they'll shuffle back and forth between the two sides. Uh, I've seen it done in person. I've seen it done on Zoom, where they separate you in separate Zoom rooms. I've seen it done, in an actual physical building where you're in separate conference rooms. You're never going to get that in a courtroom. Like you're
No.
never going to get an opportunity to say things that, by the way, would never be able to come out of your mouth in a courtroom. There are limits, there's rules of evidence, there's rules of civil procedure. There's just things that you can't step on, where you do get that opportunity to say things and say things privately to this person. So I think that is also a benefit for people. They feel they get to tell their unfiltered story. And for people who don't really want to be in a courtroom with all the eyes on them or have the other party there, it is an opportunity to kind of break up into groups. But I think it's invaluable to get the mediator to go, you need to think about what you're doing. Right? This is not a win, because oftentimes clients will go in their mind, they believe that if the judge just knew what this
Just
other person had
do what
done,
I know.
they
Yeah.
would just go in their favor for everything. Right. And I think that they need sometimes someone besides the attorney going, no, like, no, that's not exactly how it'll go down. Like, even so, that doesn't mean it's going to get you an advantage. It doesn't mean it's going to get you a win. Even if you said that, I think they need to hear it from somebody else. And I think that's one of the most invaluable things that mediation does. Lets them say, did you know XYZ, and have a mediator go, okay. But in a courtroom, still, it wouldn't sway me and it's not going to sway anybody else. And I think hearing that, maybe for the first time, opens up a true dialogue when they go, oh, you mean there's a chance somebody else hears this and then I don't just win?
One of the things that you mentioned during your discussion is that the mediator has the opportunity to speak to the parties privately. It's as they do with arbitration, depending upon the contract that you agree to. Mediation has with it something that is incredibly important that litigation does not. It's called confidentiality. I cannot repeat that which you tell me in private, so that I can sit down with the parties and say, okay, tell me what you really need. What's going on here? And they can say, those half cans of paint in the garage, we really need them. Okay. It's something that's really important to me. And we're not telling the other side because we don't want the other side to know what it is we really, really want, because that means they can leverage us to get more for it. I can take that information, go back to the other side and say, what are you willing to give them for what it is you want? And when they're talking about it, say, what about these things? These half cans of paint, do you want those? And they, by and large, go, no, we don't really want them. I said, well, why don't you trade them then? And you can work deals that the parties, if they did not have that third party involved, would be afraid to speak to each other about, for fear of giving the other party too much information about what's important to them. Because when you get into the zero-sum game of litigation, sometimes you don't want the other party to know ultimately what's important, ultimately what you're looking for. There's a story about two sisters fighting over an orange. They both want the orange, and mom doesn't know what to do. She pulls them apart and says, why do you want the, why? Why do you, well, I want the skin of the orange because I'm making a zest. And goes to the other one and says, well, why do you want it? Well, I want the juice. Well, you know what? Gosh darn, why don't you talk to one another? Because that one orange can now serve purposes for both parties. Mediators are able to find out from each party what it is that's important to them that they're afraid to discuss for fear that the other side will use it somehow in the litigation against them. It and and I hate to raise it this way, but I will. Um, when you are a Superior Court judge, if you see a fraud going on or a criminal act going on, you're under an ethical obligation to report it, period. So if you're sitting there and you see somebody who's driving a Lamborghini, or maybe two or three of them, and has a $5 million home and is claiming an income of $14,000 a year, and you're saying there's income tax fraud going on here, you may have an obligation to do something about it. You're not law enforcement, but you are an officer of the court. As a mediator or even binding arbitration, I'm not an officer of the court. I know it sounds strange, but the rules are different. I'm bound by confidentiality. And if I see that landscaper who's got the $250,000 cash, in his safe and is reporting an income of $30,000 when he's got, $500,000 worth of equipment, and it's a gross example. No, it's not that bad usually anyway. I don't call the IRS. I can't. I'm precluded from doing that. I am under an ethical obligation to keep it quiet because of confidentiality. And it becomes a vehicle for resolution that doesn't jeopardize the litigants with, quite frankly, criminal prosecution because of their conduct during their lives. Now, having said that, if we see a future act in the making, we still have an obligation to report it. It's only things that happened in the past. So this has distinct advantages for businesses in as a result of the confidentiality, and as a result of the fact that there is, in fact, an ethical preclusion for discussing it. In addition, does any major corporation want to know that they've been held responsible for some civil rights violation? You
Well,
can take it.
certainly not with a reporter sitting out in the courtroom. I agree with that.
I'm doing some work for one of the local universities on an LAD matter, law against discrimination, and it's a three-member panel. And the head panelist will have to write an opinion. That information, whether if I find that there was a violation of their, Title IX, which is basically a sexual harassment type of stuff, discriminatory conduct by one of their professors or by somebody employed by the university, that goes directly to the university to do with as they see fit. If I'm trying this case, it's an open court, period. So there are advantages within institutions. I don't think Procter and Gamble or Ford wants a big splash that they've been not promoting people as a result of some racial discrimination, a sexual harassment is going on in the work. They don't want that reported. Do it in-house. I hate to say keep it quiet, but that's one of the advantages that's offered by doing a contractual mediation and or binding arbitration in-house with an agreement to privacy. There's really a great deal of difficulty getting a settlement, or at least what's going on the record, private. In the court, you can agree to seal a verdict in terms of the amount, but the fact that litigation went on, that's public.
Sure, and often the testimony, while there are limited circumstances where I've seen judges close the courtroom, oftentimes, there can be, even if there's no cameras allowed, there can be reporters in there who tell, so to speak, or summarize, what has happened that day in court for the press.
About 2 years before I left the bench, the Administrative Office of the Courts promulgated a rule that permitted cell phone to do recordings, individual cell phones to do recordings in the courtroom. They would not be official transcripts, but they could literally, to preclude it from happening, we had to state on the record, the reasons rather, why we would not permit someone to have their cell phone or record what was going on in the courtroom. And my recollection is that happened on one occasion when I had a informant testifying and a gang member coming in with his cell phone, and I said no recording of this witness's testimony. But it's very, very rare.
Right. So, I mean, there's an element of that. Certainly in big business, I think that's what's made arbitration so popular. Right? The ability to not have public coverage to kind of settle your disputes privately. And again, I mean, I want to circle back uh, to the cost, right? The difference is because oftentimes clients, and Shaun, jump in if you think you've had a different experience, they squawk a lot over there's a cost for mediation. And it's really important, I think, that clients understand you are saving a ton of money by going through with a mediation and settling, as opposed to going all the way through to the end. I mean, let's talk a little bit about like the cost of taking a case all the way to trial.
Yeah, the cost associated with trying a case from start to finish, depending upon the subject matter, can be question mark. Pick a number. Um,
1.2 million.
1.2 million. I like that. It's a good number. In terms of, alternative dispute resolution, whether it's mediation, whether it's arbitration or otherwise, obviously you're getting ahead of a lot of the uncertainty. We've already talked about that. But you can move it along. You're not dealing now with the court's calendar and scheduling a hearing for 30 days from today. If the arbitrator or the mediator is available, you can get right into it. So that's an incredible bonus to a situation where parties are trying to get to a rapid resolution. Um, you can really end a case before it even begins in an ADR forum. Um, a lot, I hate to say this because I'm a lawyer, I'm a member of the bar, but a lot of times cases are prolonged because lawyers are overworked, the courts are overworked, and that ends up escalating into, prolonged periods of time within which you get before the court on a motion for summary judgment. Or there's a motion to compel discovery because somebody sat on their hands. Um, you know, I, you don't blame anybody necessarily, but this is just the harsh reality of the litigation world. And oftentimes that stuff can be done away with from a cost standpoint and from a time standpoint in a mediation or arbitration forum. So obviously I'm a huge proponent of it. And again, I really believe you got to get the right person to mediate your type of case. Again, Judge Ferencz went into this about somebody who has an understanding of what nails in a hammer are if you're dealing in a construction case. If there's an insurance coverage dispute, you want to know that you have somebody who really understands the basic concepts in insurance coverage. Obviously, somebody who's going to handle a family law matter, you want to have somebody who understands that and the financial issues and implications that go along with it. And personality types are also a consideration. So, there's just a lot to it. And I think there's so many different factors that the parties can ultimately control. Again, it all comes back to control, controlling the cost, controlling the risk, controlling the time, controlling the parties that are the players to it, and controlling the outcome.
I'm harking to a story that was told by Art Buchwald, a columnist that we might recollect, but any of the younger folks that might watch this probably will not remember. But he was a columnist and writer, and he told a story about suing somebody, and he was successful. He got a $500,000 verdict, and he was very, very happy with it, except that it cost him $1.2 million to litigate it. That's where that $1.2 million comes from. And that's an unfortunate reality. Lawyers are costly, and they work hard and, earn their money. But I think if I were to ask any trial lawyer or any litigator who's been in a courtroom, whether or not when they get ready for a trial, if their trials go or their motions go immediately, they would say no. If they heard on time, they would say no. It was not unusual for a motion to be adjourned 2 and 3 or 4 times. It is not unusual for a trial date to be postponed 2 and 3 and 4 times. But when you hire, literally select somebody, and quite frankly, paying that person to have a trial date or to have a mediation date, two things happen. A, both parties are splitting the cost. So both parties, if you will, have skin in the game. Both parties are agreeing they want to get it done. Both parties are going to show up. Both parties are footing the bill. Both parties have an invested interest in resolving the matter. B, guess what's going to happen on that day, guys? You're actually going to have the attention of the person you've hired. Because if he wants to get hired or she wants to get hired again, they're going to do their best to be there on the day that you've retained them for, and to be there and only do your matter. I am reminiscent of my time in family when they would have a 9 o'clock call and a 1:30 call. And I didn't think that was fair to keep a lawyer, get them there at 9 and not hear the case till 11 or 12, or maybe not even till the afternoon. So I started staggering all of my motions, all of the matters that were coming before the court on any given Friday. They were 15 minutes apart. How much time do you think each of those motions got from me or any other judge when I had a motion every 15 minutes? Shockingly, I will tell you that some of the times lawyers would walk in and I swear I knew more about the case than they did. But for the most part, you don't really get to focus on a case. When you hire a mediator or you retain an arbiter, that's their case, period. And they take as long as is necessary to understand your case and to talk to you about the case, to prepare the case, and to hear it. It's a very different process, though I will say you've got to be careful on a lot of the mandatory arbitration clauses in contracts, because remember who picks the arbiter. And if it's the corporation or the employer that picks the arbiter, then you need to be cautious that that arbiter may have a built-in preference to satisfy the person putting his bill. Okay. And you need to be cautious if you are in that situation that the person that is being selected is somebody that your lawyer has some input into in terms of finding out and determining who it is. Because if it's somebody who is working only for XYZ Corporation, only for a particular company, and that particular company is paying 90% or maybe all of, his, monthly income, you might not get the fair objective evaluation that you want. So when you talk about binding arbitration, I say to you, make sure that each party has equal access and input to the person who is going to make the decision, and make sure they're not the person making the decision isn't in any way tainted by prior relationships. I could go into the obligations an arbiter has to disclose those, but I think it's enough to say that you need to be cautious about who you're hiring and what their relationship is with the parties.
Well, a lot of times, like with PIP arbs and things, they take it one step further, where each side gets to pick a person for the arbitration, and then the two arbitrators pick the third,
Correct. And
right?
the third person makes the call.
Ultimately,
Then,
all right.
then each of the two arbiters who are with the actual decision maker make recommendations that are different, but ultimately agree with whatever the resolution is. Yeah.
Yeah. So, I mean, I guess that's one of the things I really just wanted to focus everybody on, that this is not a bad thing. Like mediation, arbitration, these are good vehicles. Unwittingly traveling the path of the courtroom, while, yes, you're going to get your day in court eventually. There have been many times I've shown up for a trial, prepared to go. Trial
I hope not before me.
materials many times before you, judge, but between with a whole host of different judges. And I've been there prepared to go. And, you
Didn't
know,
get reached.
there's other hearings coming in that day. There's emergency hearings coming in that day. Or I've waited till 3 o'clock in the afternoon to get an hour,
Yep.
of a trial in, and told to come back in 2 weeks.
I remember trying a case. The trial, the case took me over 9 months to try the case.
In bits and pieces with notes and piecing together the last time everybody was there.
Right.
So I mean, I think people have to be mindful. It's not like you see on television, right? When you see on television, no court case is heard, and like every witness goes after each other, and it's one day after another, and you have the judge's full undivided attention. Yeah, I don't know many courtrooms that actually happens in.
Doesn't even happen in the criminal part, where you might expect it to happen more often because you have a jury making the fact finding. So you have outside citizens coming. So the judiciary is very attuned to getting cases run in a smoother, consistent, consecutive kind of pattern. So I think what you're saying is absolutely 100% accurate.
Yeah. I think people need to understand that. Like your case is going to take a long time, right? That's just how it works. And it's not, and you're going to pay for time where your lawyer's just sitting around. And I know that seems unfair, but they're at the courthouse to represent you. It's not their fault that maybe the case doesn't come up until 2 o'clock in the afternoon. And that they're gonna keep going back and doing that. I mean, it is your opportunity to control the system, control the narrative, to put a timeline to cap your costs.
You just put, the proverbial, and I think now that I'm saying this, I can now do construction cases to put the nail, if you will, in the 2x4. I mean, that's exactly what it is that we're talking about in terms of taking control of the process. See, mediation is basically an assisted negotiation. Like your neighbor tree falls on your yard, you go and talk to them. You have a fight, we'll go get another neighbor to come in and talk to you and try and help work it out. It's like family disputes. And you go from that to arbitration, which can be binding or non-binding. And I suggest that by non-binding is just making recommendations, which is fine, but they're kind of meaningless, but they're making recommendations. To binding arbitration, which at least is going to come to a resolution, going to come to under your timeline. You get to pick who the person is that's going to do it, get to pick the person's expertise and the background, so both you and your attorney feel comfortable with it. And not more importantly, but also importantly, which we haven't touched on, the New Jersey court system is bound by pretty strict structure, New Jersey rules of evidence. And if you don't comply with those rules of evidence, evidence that it's true can't come in and can't be considered. In arbitration, you can relax the rules so that when you get a deed, for example, from a particular house or from a particular business, get a contract, or you get the corporate papers, you don't have to bring somebody in to verify that these are in fact the corporate papers, that this is in fact the deeds of the house. You can really streamline the process and save the cost, if you will, of having to follow the New Jersey rules of evidence. It works to the betterment, if you will, of all parties in terms of streamlining the process.
Sure. Authentication, right? You need to, you get a stack of bank records. You want to use those bank records to show something. I can't just come in with the bank records. I've got to bring a custodian to say, yep, I work
Even
for
though
PNC.
we know those are the bank records. Nobody really, yeah. One
In a
of the
trial, that's the process, though. You've got to follow the rules. And in a courtroom, I have to bring somebody in from the bank to say, we got a subpoena, we did a diligent search. These are the actual records for this period, for this account, or for this person. Just to authenticate them, right? The court is there to ultimately get to the truth. So our rules of evidence are geared towards the truth, right? The best ways to assure that the evidence coming in is what it purports to be, so that there are specific rules to be followed, which I'd argue in some cases seem like they go above above what's necessary, right? If PNC mailed me a package and said these are the bank records, well, okay, that ought to be enough. That package typically comes with a certification that says, hey, these are the records you asked for. But in a courtroom, that's still not going to be good enough. I'm going to have to go one more step and go to authenticate those records.
One of the other things about trials and courtrooms, if you want to make a motion, you literally have to file paperwork,
Absolutely.
lengthy affidavits. You give the adversary the time to answer. when you have a binding arbitrator, you can literally send an email and say things like, "Hey, do you know whether that?" And that arbitrator can contact the other party and say, "Did you in fact pay the mortgage for this month? And could you please provide proof that it was paid?" If you wanted to do that in a courtroom, you'd have to file a formal motion, which would then be responded to by the other party. Meanwhile, if the mortgage on the house, for example, is not being paid, on the building is not being paid, you can end up in foreclosure and all the problems that arises, that comes up as a result of that.
And the amount of time it takes to get before the court on any given
Oh,
issue, right? There's
mhm.
a very limited order to show cause, or what we call the words we use for an emergency motion, right? There's very limited reasons that a court can hear you on that kind of a quick basis. And
Mhm.
believe it or not, like foreclosure is not one of them.
Not one of them.
Right?
But
It's
on the other
not. I
hand, if
mean,
I'm
the
getting,
person didn't pay the mortgage, you're worried that they're going to foreclose, you're worried it's going to hurt your credit. It's still, you
you're
got to
worried,
file that on a normal schedule
how
and
about
have
you're
it
worried
heard
that
whenever it's heard.
the insurance is being paid and the business building is going to be burned down, or something's going to happen. There'll be an accident, a construction accident. Do you want, if you have an interest in that building and that company and that business, to ensure that the business insurance is being paid? Of course you do. What would you have to do to get that before a sitting state superior court judge? File a motion, have a response, have it scheduled. What do you think, as 60 days? A month?
You may be in the zone.
You know? On the
We
other
Yeah,
hand, with the
I
we
binding,
mean,
we file a lot of orders to show cause, okay? And it could be pursuant to Rule 467(1), which is the summary action rule, or trying to get injunctive relief for the very things that you're talking about. And some judges find it to be more emergent than some others may find it to be. So
that's your other problem, right? There's
right,
some judges who may relax the rules and hear something on an emergent basis that an ordinary judge might not.
exactly.
And that's one of the rolling the dice in a courtroom, right? Because what happens in room 301 might not happen in room 302. You have different judges who bring different backgrounds and training into that case. So it, I've had this experience where clients say, well, my friend, right? My friend appeared in this courthouse before a totally different judge, and this is what happened. And you have to say, but that's not who you have, right? Like you may not get the same outcome with this different judge that you might in the other courtroom. And
Mhm.
that's a harsh reality that you have to face as well. It's every case is different. The facts are different. You might not get the same outcome. You shouldn't be bolstered by like, oh, my friend went and this is what happened. It may not happen the same for you. I mean, you have to, I think, have a large dose of reality that the system is geared towards doing what the court or a judge thinks is fair, and what one judge thinks is fair, another judge might not think is fair. So there is that aspect to it, right? Are decisions supposed to look more uniform? Sure, right? It's like getting a burger at McDonald's. It's supposed to look the same no matter what McDonald's you go into, right? But the courtroom isn't quite like that. You do get different judges who see the exact same issue differently. So you keeping that in mind and feeling emboldened by like oh, I'm going to go through the whole process and I'm going to win and I'm going to get all my counsel fees back. That's really
how
uncommon.
often do you get counsel fees back, Shaun?
Every time, gosh darn it. No, I
Yeah,
mean, look, it's
well,
and I've also, maybe you folks have had the benefit of this, but I've had clients tell me, Shaun, I'd rather pay you than pay the other side. Is that a stumbling block to sitting down to a mediation or some other form of dispute resolution? Of course. Is it surmountable? In some cases. But look, the reality is most cases are ripe for a dispute resolution forum. There are a handful of cases that simply it won't work because of personality issues or because an answer needs to be delivered by a court. But in the end, most of these cases really are perfect for ADR.
Well, I think I'm going to close on that note. I hope that in some way we've been informative for somebody who is trying to make that decision, or just this court is being forcing you to enter into a mediation. I hope that you get a little bit more feel for the process. You can create a different ending. You can create your own story here, your own ending by having control. And this allows you to create something that's maybe outside of something a court can do. But you and whoever you're fighting with can create something different that might work for everybody. So I encourage you to take this process seriously. I'm certainly going to put links up to Shaun and Judge Ferencz's firm so you can check them out. It's a great place to start, especially if you're in New Jersey. And I'm going to say, does anybody, do we think we covered the basics? What do you think?
Basics.
The
Yeah.
basics. So I
I,
think,
I will say as a closing statement that it is so cost effective as to be foolish not to give it a shot. And secondly, I am harking back to one of the things that I referred to, and that is nobody likes to be told what to do. And when you resolve matters by mediation, by negotiation, by talking to one another, especially with a third party who's trained to help you resolve matters the way that you want them resolved and need to have them resolved, you walk away with a sense of satisfaction. You walk away invested in the resolution. There are fewer appeals because people they've agreed to it. When a court orders you to do something, and I'm fond of telling people during the initial process, you get a jury verdict, comes down, you got sitting on top of the world. Guess what? That gets appealed. And it can be 2 years before, in fact, the appellate division tells you, no, sorry, start over. So that doesn't happen in mediation because you've agreed to the resolution and it's very, very limited appeals. It makes so much sense. And if it doesn't work, litigate. Then you still have a right to try it because everything you said during the mediation cannot be used against you because of the privacy, because of the confidentiality, because whatever you say to the mediator, it's like Vegas. What happens in mediation stays in mediation.
and that's the perfect way to end the podcast today. So I want to thank my panelists and say have a great day, everyone.